about that considering that the government records are more than 15 years. So those remarks refer to government records which are more than 15 years. So if it's more than 15 years, you cannot probably recover them anymore. So, but if it is less than 15 years, you can recover. That's the meaning.
But Richard Pascual, in his phone conversation, only asked me about by 1994 to 1999. So that's
Ask the isn't
No, I simply said I was considered as private sector when I was first appointed, so that's the rule I think that will be followed. That's in my letter. And so he said 94,
So he did not ask for your SAL-ends up to 2006?
No.
He did not?
He did not. Even if he says, my letter is clear. If it was untrue, he should have clarified in evidence between a general recollection and a note or memorandum contained in a formal letter sent to the JBC, giving the specific content of the conversation between Attorney Pascual and myself that governs.
Attorney Pascual was more interested in 15-year-old records or older than the more recent ones, in effect.
In effect, that was how I understood.
Yeah, that's how he wanted. He wanted your older records, which could probably never be recovered anymore.
Yes.
He was not interested in records that could be recovered.
Yes, I just reminded him I was...
So isn't it your obligation to produce these SAL-ins? Why do you just rely on what Richard Pascual is telling you?
Because I don't know what's happening inside.
You are required to file all your SAL-in. And as you mentioned, you're disputing the 10 years. Okay, it's up to you if you want to dispute that. But there is a marked disparity between our submission and yours. You did not submit a single SAL-in from UP. Why? So you submitted only your SAL-in that you filed in the Supreme Court. But you worked in government in UP for 20 years and not a single SAL-in in UP.
Your Honor, since I started teaching, I have moved residences 7 times. One of those movements was abroad, where I left all my documents with other people. I have not been a religious keeper of my UP documents. So after that explanation, anyway, the minutes will show that any of the members can ask me during the interview or clarify at any time. No such clarification was made. So what am I to do? I didn't even know how the JBC was looking at my application.
Okay, so you did not submit a single SAL-in. When you applied for Chief Justice, you did not submit a single SAL-in that you were required to file during the 20 years that you were in UP. And you want to compare that with us and with the others. But you submitted only, okay, 2009, 2010, and 2011. And the 2009 is very irregular because that was, you were not in government service on December 31, 2009. And yet, when you assumed office as Associate Justice of the Supreme Court, you did not submit your SAL-in as of August. I think you were appointed August also.
I dispute your use of the word irregular, Your Honor.
Okay, if you say, okay, I will just state the facts. You, instead of submitting a SAL-in dated as of the date you assumed office, you submitted a SAL-in for the, which is 8 months before you assumed office. That is a factual statement. So let the court take that into consideration and decide what to do with it.
I did not, again, the question is, I did not submit to the JBC.
No, you submitted.
Are you saying no, I did not submit to UP?
No, you did not submit. When you assumed office, you submitted a sworn statement of liabilities as of December 31, 2009, when you assumed office in August of 2010. So your statement of assets and liabilities as of August 2010 should have been dated on as of that date. And so when you submit your SALN, when you applied for Chief Justice, you submitted the SALN for December 31, 2009. When you should have submitted your SALN as of August 2010. That is just a statement of facts. Statement of facts.
Justice De Castro,
no annotation, no.
it was completely accepted. That 2009 SALN was completely accepted by the JBC.
You mentioned that you had the problem about taxes, so you were not able to date your SALN in August 2010 as of that date, and you dated it December 31, 2009. That was your explanation. So let us leave it at that. That was your explanation. And
You mean, if I have already a 2009 SALN, which is on file with the clerk of court, I have to execute another one in 2012 and date it as of September 2010? Is that your implication?
That's not the point.
Oh, what is
You
the
should
point?
have submitted, when you assumed office in August 2010, is your SALN as of August 2010. Not a SALN as of December 31, 2009.
So it is not an acceptable entry SALN? Is that the point?
From my reading of the law, that is my conclusion. But
So it was a defective submission to the clerk of court. That's your point.
when you assumed office in August of 2010, and you submitted a SALN for December 31, 2009, which has no relevance at all.
So you mean, I was already with the court, and then when they said submit all the SALNs,
Not all. Submit your
current SALN, I have to make a computation again?
No,
Is that it?
No, you are not required by law to submit a SALN as of December 31, 2009, because you mentioned that from June 1, 2006 up to the time that you assumed office on August 2010, you were no longer in government. So why is it that you have a SALN for December 31, 2009? What is that for?
Your Honor, if there had been any problem with my SALN, Chief Justice Corona should have called my attention because he is the head of the judiciary. Under the procedures, he should have called my attention, mali yung entry SALN mo. Bakit masyadong maaga? Bakit December 2009? Eh, ang reading ko ng batas, kung N2009, pwede na yon sa entry SALN kasi yun naman usually, at yun ang sinabi sa akin, N2009. Yun ang hiningi talaga.
Cite other people, you are the one concerned here.
No, that's the reality.
You are being asked about your compliance with the SALN law, so don't blame other people about your failure to comply.
Justice De Castro, I never knew what was happening inside the JBC. I received a call, I responded to the call, I knew nothing about what happened inside the JBC. Now, if they consider that as sufficient, then that's it. It was sufficient compliance. How could I have second-guessed what Richard was conveying to me, what the members of the JBC were talking about? I never knew any of those things. Everything was in good faith, done in complete good faith. If they found that the 3 SALNs were not enough, then they should just have struck out my name. But they did not. And they had 11 chances to strike out my name.
You're saying it's the fault of the JBC.
It's no fault. It was a perfectly legitimate act.
Okay, so when you applied for Chief Justice, you submitted only your SALN for 2009.
Yes.
Which was SALN for the time that you were not in government yet, and your 2010 SALN and your 2011 SALN when you were an Associate Justice of the Supreme Court, and not a single SALN from UP. And so now
if the JBC had said, sorry, you're dropped, I would have accepted that.
But you wrote a letter saying that you cannot find your
Because
SALN.
I was told a Friday. I was required to submit all on Monday.
But you had a SALN of 2006 when you applied in 2010.
It's not a 2006 SALN.
Oy,
Written date prevails over the printed date.
So the readily available SALN, if you really went to UP, you could have easily gotten 2002.
How could I have gone to UP? I was working in the I was already working inside the Supreme Court. We had a lot of work. So I just called UP. They said, it's not in your 201. Please write. So why?
Well, we were all working also in the Supreme Court, but we were able to produce our
I had left UP a long time ago.
15 years, and even my SALN in the Saldigan Bayan, I was able to produce even, and I didn't make the excuse because if you're applying for the highest post of the land, why highest post in the judiciary? Will you take that attitude that you have no time? You are a spy.
But that's the reality. That's the truth. If they had said, oh, we will give you 1 month, 2 months. But they did not. They said, by Monday. Okay, so what could they do? The only feasible step was called. And they said, it's not in your 201. Maybe it's in the central. It's in the central. Go write. Okay? And say, if I write, that would already be Monday. So I said, these are old because Richard was basically trying to ask me, where is your 95, etc. Okay, I said, it's difficult to look for them. And I always considered myself as having been considered as during the time that I was in the private sector, those requirements were not applicable to me when I first applied in the as Associate Justice.
So why did you submit a SALN for December 31, 2009 when you are not a member of the court at that time?
It's as of end December 2009. I am reporting it. I am entering government. Mr. Government, this is how my assets look like in December 2009. Kaya po namin i-measure at i-define kasi yung tax filings namin kompleto na as of April 2010. So kaya na po namin may measure yon. That's why, yun po ang aking entry sa akin. Kung mali po yun, sana sinabihan ako ni Baby Vidal, pero sinabi niya, yan ho ay tamang SALN. Sana sinabihan ako ni Chief Justice Corona, walang nagsabing kulang o mali.
The point is,
you also, with the consent of your client, allege that some applicants for the office of the Chief Justice didn't also comply with the SALN requirements. Is that correct?
That's true, but they submitted explanations.
Do you know that this argument of yours is a fallacy, which fallacy is called tu kokwe?
I don't think so.
That is appeal to hypocrisy?
No, I don't think so, Your Honor, because the petition...
Can you just let me finish first?
I'm sorry, Your Honor.
A fallacy tu kokwe is a diversionary tactic by using the fault of others to justify your own fault. Now, when you made that argument, were you aware that there was such a fallacy that you were violating?
Well, I don't agree.
That you were using the fault of other applicants to justify the non-filing of SALN of your client.
With due respect, I don't agree. If you recall, the petition says the Chief Justice was given favored treatment in violation of the Equal Protection Clause. That charge made relevant our position that the substantial compliance rule was extended to everyone. So the Chief Justice could not have been given preferential treatment. And the reason why we alluded to the status or the condition of the submission of the other applicants is to show that the substantial compliance rule was applied uniformly. In fact, it was extended to 14 out of 20, and among the shortlisted of 8 candidates, 6 were extended extended the substantial compliance application. So it's not a fallacy. I think our position, which alludes to the number of SALNs which the others did not submit, is very relevant.
Thank you very much, Attorney Poblador.
Justice